Thanks, Pam. Welcome to our session on arrangements with third-party creditors and when and how you need to deal with them in secured financing transactions. My name is Matthijs van Galen, and I'm an associate at the Gowling's Hamilton office, and my specialty is mid-market financing transactions. Today I'm joined by Richard Dussom, who is a counsel also in the Gowling's Hamilton office with over 30 years of experience in lending and secured transactions. We're going to have a look at 5 types of third-party creditors that a lender may need to deal with on a financing transaction. We're going to spend some time examining the documents that formalize this relationship and specifically some of the key elements that you need to consider. Over to you, Richard.
Thanks, Matthijs. As Matthijs mentioned, today we're going to look at the who, what, when, and why in terms of dealing with third parties in a lending environment. And specifically what that means is which third parties you need to deal with, what documents you need to use to deal with those parties, what provisions need to be included in those documents, and when and why you need to use those documents. So all the W's we hope to cover for each of the documents we're going to speak about. And to keep our discussion focused, we're going to look at things from the perspective of a senior lender on a new financing for a prospective borrower in Ontario, where the new borrower is operating its business in the province, and the lender has done all the traditional searches for PPSA, Bank Act, other lien searches, and has done executions and so on and so forth. So we're looking at a traditional transaction from that perspective. And the guiding principle that we're going to use in all of this is that you have to remember as a lender that you cannot bind a third party through a simple covenant in your loan agreement. Negative covenants are just not enough. So a negative covenant prohibiting payment to third parties in the loan agreement is fine, but if the borrower breaches that covenant, all you have is a covenant breach, and if it's drastic enough, you can pursue a realization of your security, but you're not in a position to claw back that payment from the third party unless you have a third party document signed by that third party agreeing that it will not accept that payment. So, as I said, the solution to the problem in each case is to obtain some form of a signed agreement from the third party that will specifically bind them to the covenant that you're seeking to obtain from them. So next, if we want to determine which third parties we're going to look at, if we do it a game show style, 100 lenders surveyed, top 5 answers on the board, here's the question. Name a third party who can affect the enforcement of your security over a borrower. And if we ran that, we might have a board that showed us the following entities that we're going to deal with. Term lenders, vendor take-back lenders, and junior lenders are all one category. Equipment lessors, motor vehicle lessors, and PIMSI holders, a second category. Landlords, number 3. Number 4 being related parties, shareholders and guarantors. Number 5, creditors of the target in an acquisition financing. So it's a broad-based group of third parties, and each one has specific elements that are important for the purposes of this discussion. So if we look firstly at the term lenders, in terms of getting, I guess, a closer insight into why you need to deal with them. Term lenders and vendor take-back lenders, junior lenders, they're a category of entity that in most cases will have security over a broad range of the borrower's assets generally. So there is the potential in that situation for there to be some overlap in the security packages that each of the lenders is going to obtain. So remember, we're acting as senior lender, so there's another junior lender or a term lender. There may be very well some overlap in the security packages that each is going to have. And because of that overlap and because each party has an interest in how the other lender deals with its security, it's a perfect situation to have an intercreditor agreement, or sometimes what we call a priorities agreement, where we sort out those priority arrangements as between the lenders, so that if one lender is going to have first security over all assets and another lender is going to have a second ranking security, that can be covered. If it's another situation where one lender will be having security over accounts receivable and inventory, someone else has security over equipment and intellectual property, that can be addressed as well in a intercreditor agreement. So the most important thing to remember when dealing with intercreditor agreements is that one size does not fit all. I mean, we've said that before, but it's important to remember, because in many cases, I'll get a call from a client saying, Richard, on this deal, we're just going to use our standard form intercreditor agreement. And then the first question I would ask is, well, does that fit this deal? Because it may very well cover a number of things that you might want to deal with, but is it, directed and something that will work well with a specific transaction? So you have to remember that with every intercreditor agreement, it all depends on what types of facilities are being offered by the different lenders, what types of security they're supposed to have in their security package, and basically what is the business deal as to who is going to get priority over specific types of assets and what other terms are going to agree to. So in terms of intercreditor agreement and some of the important elements that you may want to include in the agreement, once again, keeping in mind one size does not fit all. Not each of these provisions I'm going to talk about will require specific inclusion in your particular deal, but they're just intended to highlight some of the different provisions that are often included in intercreditor agreements. So one of the basic provisions is defining each of the lender's priority collateral. So if we are the senior lender, we're going to want to make sure that our priority collateral is described as all of the assets of a specific type, or maybe we're only getting, in this situation, accounts receivable and inventory, and then there's another term lender that's providing financing for the inventory, or sorry, for the equipment and the IP. And the important thing there is to make sure that someone gets the benefit of all the other assets that aren't immediately apparent in those two baskets that we've just mentioned, because that could end up being an important asset, and it's important that primarily the senior lender get those extra assets in the basket that no one has specifically identified. Another important provision in an intercreditor agreement is what we refer to as the enforcement standstill. Now, an enforcement standstill is basically a prohibition or a limit on a junior creditor's rights to enforce its security generally, or as against the senior lender's priority assets. And the reason why that's specifically important in almost every deal is that the senior lender will want to, in almost all cases, be able to control the enforcement of the security against the specific assets. So we're looking at the only way they can do that and to exercise that control is if they are limiting the rights of the other creditor to exercise that enforcement. Next, moving along, is what we call a proceeds waterfall. That's just a provision that basically divvies up the proceeds of any realization on the assets. And the important thing that might be included there is a limit on a specific lender's priority. So maybe the senior lender does have priority to accounts receivable and inventory, but maybe that's capped at $3 million or $10 million. That's important to be in the proceeds waterfall. A payment standstill is similar to an enforcement standstill in that the senior lender is looking to control what payments are made by the debtor or the borrower to a specific third party. So there's going to be a list of payments, and in terms of an event of default, we do not want payments being made to that other secured creditor that are outside of the specific list. Another provision is the permission of amendments to the senior lender's loan documents, because inevitably the borrower is going to come back and need some changes to its credit arrangements. The senior lender doesn't always want to have to go back to the junior creditor and get their consent to that transaction. So we'll often try to bring those provisions into the initial document. And sort of the other flip side of that is that a junior lender will want to institute some protections for itself in terms of limiting increases in the senior debt. The last couple of provisions that you may want to include are a restriction on, sorry, not a restriction, but rather just a statement that the operating lender is allowed to basically operate the account in the ordinary course until such time as there's an event of default. There's no obligation on the operating lender to basically look into each deposit that might be made to determine if that constitutes the proceeds of the junior lender's priority assets. And lastly, just a clause that would allow access to remove the collateral. If there is a term lender that happens to be a mortgage lender, the senior lender wants to make sure that it has access to remove the accounts receivable, inventory, and equipment, and so on and so forth in that situation. So that's sort of the intercreditor agreement. Now we'll go over to Matthijs to talk about dealing with equipment lessors, motor vehicle lessors, and other PIMSI holders.
So this is one of the most important topics because it happens all the time. When you pull a PPSA search, you see registrations in regards to equipment or vehicles. And it often happens on transactions where a financial institution won't be retaining legal counsel. So it's one of the most important things for bankers to know. And that is that when you see a registration that lists a piece of equipment or vehicles, it doesn't necessarily mean that that registration is limited in any way to just that piece of equipment. In Ontario, if the box is checked where it says equipment and the general collateral description does not contain any language or specifically limiting language that limits that registration just to the listed piece of equipment or vehicle, then it theoretically could not be, it may not be limited based on what the security document says. This financier could have a much wider reach. So what can a bank do to make them comfortable in that situation? Well, the document that we obtain is called a PPSA estoppel letter. And what this does is it has the financier acknowledge that their registration is limited in scope to just the piece of equipment or vehicle that they're financing. And this is very important because a lot of banks, specifically operating lenders or financial institutions, want to know that they're in first priority and not subject to this, subject to that. So what the PPSA estoppel letter does is it provides confidence to lenders that their first priority is, in fact, first priority, subject only to the finance piece of equipment. And there's a couple key things for us to consider in regards to a PPSA estoppel. First is that this is Ontario specific because we have a check the box system where you can check equipment, accounts, inventory, other motor vehicles. Other provinces will have it so that you specifically define the equipment and then it doesn't go further. But in Ontario, if you check equipment and only list the piece of equipment, it reaches all equipment unless it's limited elsewhere. So the risk is that if the senior lender does nothing about it, they could lose their first priority status. And the letter, its components are quite straightforward. One, it has to list the piece of security that's financed. Two, list the registrations that it deals with, and then say that the registrations are limited in scope to the finance piece of equipment. And that is one of the most important things bankers should consider when they're pulling PPSAs and consider whether or not a lawyer is engaged. So with that, I want to hand it back over to Richard, who will be speaking about issues surrounding landlords.
Okay. So landlords are someone that every lender is going to have to deal with whenever the borrower is a tenant of leased premises, and that covers a lot of borrowers. So the landlord is an unsecured creditor that will not show up on any PPSA search that you do. Rather, their rights as an unsecured creditor that are important for the lender to consider arise by virtue of either the legislation with the Commercial Tenancy Act or else the lease document itself. And one of those rights that we often have to deal with is what's known as the right of distraint or the remedy of distress. And generally speaking, that's the right that gives a commercial landlord the ability to enter the premises and seize and sell a tenant's good in order to satisfy rental arrears. And so in order to address this situation, the lender will need to obtain a landlord waiver, which is usually a document signed only by the landlord, but can be signed by the lender as well, depending on how complicated the provisions are, as we'll notice in a moment. In terms of the actual landlord waiver, once again, one size does not fit all. Some landlord waivers can be very simple. Others are more complicated, where there's more complicated rights that are looking to be preserved on the part of the lender. In terms of some important elements, one thing that we do always want to include is a waiver of the right of distraint. So what that means is that the landlord is not going to have the ability to come into the premises and seize and sell the assets. It's very important for the lender to be in control of that process of realization on the assets for the reasons we talked about in the intercreditor arrangement. We also want to have an acknowledgement of the security interests so that the senior lender's security interest is acknowledged by the landlord, so that the landlord is put on notice that the senior lender has an interest in these assets of the tenant. Another provision that you want to include is to permit the senior lender access to the premises to remove its collateral in the event that there is a loan default. You don't want to be in a situation where you go to realize on the assets and then find that the landlord is not permitting entry onto the premises. In some cases, limited cases, where you have a borrower who is a manufacturer and there's a lot of money soaked up in the raw materials and inventory, in some cases you want to have a period of time to occupy the premises. Your receiver will occupy the premises in order to complete that inventory. Another important provision to have is an acknowledgement that the assets of the tenant do not constitute fixtures on the property. And the reason for that is basically because fixtures run with the land, and after the tenant were to vacate the property, those fixtures would belong to the landlord if they're completely bolted to the property and cannot be easily moved. So we want the landlord to acknowledge that, hey, those assets still belong to the tenant, they're not fixtures. And lastly, a provision you may want to include in some instances where the lease is particularly valuable and you may want to assign the lease as part of a realization is to institute a right to basically cure any defaults that the tenant might make under the lease. And that way you can preserve the lease, keep it in good standing so that it can be assigned at a later date. Now we'll go back to Matthijs for a discussion of related parties and shareholders.
So the next topic is related parties and shareholders, guarantees and subsidiaries. In essence, these are entities that generally have a close proximity. They're affiliated to the borrower or guarantor. That's often the case. And what they're often defined by is something like a shareholder loan or a related company loan, which means they're often not secured. So if you pull a PPSA search, there may not be a result there, but often it's dictated by the financial statements in terms of the loan being existing. So what are the main concerns? If they don't have a registration, you're not worried necessarily about subordinating. The bank's concerns generally focus on restriction of payments for these loans, whether it's stopping payments altogether or limiting them only to interest payments or limiting them to a certain amount of fixed principal payments. And then also stopping them from being able to enforce. So those are the two main concerns that banks would have. And that leads banks to go and get a subordination agreement, or it can be called an assignment postponement subordination agreement, or just a postponement agreement. And once again, it's not one size fits all. This document is mostly defined, similar to the concerns, by a stopping of payments, right? Or a dictating of what payments are permitted and what payments are not permitted. It has an enforcement provision, which often stops related parties and affiliated parties from being able to enforce their security or accelerate payments. And then finally, it may also include a subordination of present or future security. So just because they don't have security now, they may in the future. And what this document will do is it'll subordinate their security interest or subordinate or postpone their right to payment. So with that summary, I'll move it over to, once again, to Richard for speaking about secured creditors being the target of an acquisition.
Okay, thanks, Matthijs. Once again, this is number 5 on our list, and the Often lenders will be approached by new or existing borrowers in connection with financing the acquisition of the assets, or in some cases the shares, of a target corporation. And we'll call those assets basically the purchased assets, because that's what they're most often referred to in the acquisition document. And what lenders have to remember is that in almost all cases, these purchased assets are going to be the subject of existing liens or security interests in favor of either the operating lender of the target corporation or some other creditors that might be involved in its structure. So the chances of these assets being free and clear at the get-go is extremely remote. So you have to consider that you're always going to have to be dealing with some existing security on those assets, because that security interest is going to follow those assets into the hands of the borrower when the acquisition is completed, unless you take steps to deal with it so that the security interest is released contemporaneously with the payment of funds to that party. And the way that you do that is by using a payout letter and undertaking to discharge. And that's a combination document that deals with the payment of the target's indebtedness, and then also deals with the release of the security interest in the target's assets. So it's a must-have document in any acquisition financing that you might be making. In terms of the important provisions to be included in a payout letter and an undertaking to discharge, basically you're going to have to be defining the actual indebtedness that's being paid out, because sometimes the target might have some complicated arrangements. Maybe it has some letters of credit that need to continue on with that operating lender of the target corporation. And so those, I guess, existing obligations or continuing obligations have to be defined so that we know that upon payment of a specific amount, usually being the payout amount, then the security interest will be released. In terms of the other items that you want to address in a particular payout letter and undertaking to discharge is that there has to be an actual undertaking on the part of the secured party to discharge its security immediately or shortly thereafter receiving the funds. Rarely, if ever, are they going to discharge their security or have the discharges already ready for processing at the same time as you're financing the transaction. So you have to have a solid undertaking on their part to complete those discharges after closing. In some instances, you're able to actually include a provision whereby that lender of the target entity will authorize the counsel of either the borrower or the target company or of the new lender to make those discharges on its behalf. And that certainly speeds up the cleanup of the register, the security register, and helps to, I guess, keep everyone happy that those security interests are discharged. In terms of the other provisions that you might be including, you try, if you can, although in some cases it's not possible, to have that payout letter actually addressed to the new financing lender. Then you have the direct covenant that we've all been seeking in all these documents, directly in favor of the lender in the event that the lender of the target fails to discharge the assets at the appropriate time. However, in some instances, lenders can take a very, I guess, steadfast position and say, no, we're only giving our letter to our particular borrower. That's the only one we have privity of contract with, and in that situation, you just get the best that you can. So that describes for, I guess, most of the things that would be included in a payout letter and an undertaking to discharge. Taze?
So thanks, Richard, for participating in this session. I know we raced through a lot of information, from term lenders to equipment lenders, landlords to targets and related parties. That's a lot of information to digest, and that's why you put together this comprehensive slideshow so you can have access to that later. But you don't even have to wait till later. We have a Q&A session coming up in about an hour that you can join. and ask Richard questions for about 30 minutes. I know I have some questions to him all the time, and I'll have some questions for him in that session as well. For now, please join us back in the main lobby for our keynote presentation.
Thank you.